there are different interests from every single stockholder.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, international commercial attorney James Raanan tears down a shareholders agreement from Ultrasonic Medical Mapping. James notes the unique context of a shareholders agreement where many of the interested parties aren't even signing the agreement. He walks through how fiduciary duties change the risks, the complexity of fairness in a document like this, and a bit of clumsy math. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose in this show is to do exactly what it sounds like. We take contracts and we beat them up. Sometimes we're nice, but most of the time we're not. We hang out with smart friends who beat these contracts up. Today I've got James Raanan coming to us from Tel Aviv today, and we are talking about a stockholder agreement. James, how are you doing today?
Hey, Mike. I'm good. Thanks for having me on. Great to be here.
Absolutely. Glad to have you. And this document, James, this stockholder agreement, it's coming up a lot. Let me show you guys the one we are using. It's among Ultrasonic Medical Mapping, Inc. As you can see, I'm pulling this from Law Insider. So you see live links throughout the document that go to other parts of Law Insider for comparative language, other definitions that look similar. But anyway, this is the document that we're going through. So James, let me come back to you. Why are we talking about this agreement, this particular one? When are lawyers going to see this kind of document?
So this stockholders agreements come up a lot in financing transactions. And the interesting thing about stockholders agreement, as opposed to in many ways a lot of the agreements that have been on the show, is that they're multilateral, right? It's not just two parties, it could be many different parties. And so I think it's an interesting agreement to talk about because there are different interests from every single stockholder, depending on where they sit, in terms of the number of shares they hold, or in terms of their own interest, whether they're a strategic investor or a financial investor. And comes up a lot in venture capital transactions, joint ventures, and really any situation where you're trying to regulate the governance of a company.
Very good. And why you? Why are we talking to you, James? What's your background? Tell me a bit about your practice.
So as you can guess from the accent, I'm originally from the UK, from England. And then I emigrated to Israel in the mid-90s and was received a baptism of fire into the world of .com. And then, at that time in Israel, when the startup nation was at its infancy, anybody who could string a sentence together in English could get a job in a corporate firm. And so I had the fortune of doing a huge number of venture capital transactions in those early years. And then as my career developed and the .com bubble burst, I moved over to become a general counsel in a large US telecoms company, where I worked for about 18 years. Became admitted to the bar in New York. So I'm admitted in New York and Tel Aviv, and I have the English background. And I've done a lot of this from different perspectives, both from the large corporate, but also the small startup, and then the venture capital fund. So I hope in some way I'm able to bring those perspectives to bear.
Very cool. You should have told me at the time that you just needed to speak English for a job. I would have flown out. If I have one skill, it's talking a lot in English. We are going to go through this document, guys, and we're going to start in very early. They do have a definition section early, and there's a definition in here, James, that was bugging you. The supermajority approval. If I scroll down to that and get some of this language, it means with respect to any matter that must be approved by the board, the affirmative vote at a meeting of the board of at least 66% of the entire board, etc. What's bugging you about this particular definition?
So, first of all, this definition has to be read in conjunction with another section, which is section 2.02. And section 2.02 lists a number of different decisions or actions that a company may want to take in its life cycle, which require a specific type of approval. So as you know, the default, if you didn't do anything in most countries and in most companies, is that the decisions come to the board, certain decisions have to be brought to the shareholders, and apart from some peculiarities, for the most part, majority approval is needed. But in in circumstances such as these, where you'll have outside investors coming in, or maybe a strategic investor coming in the context of the stockholder agreement, they will want to specify certain supermajority approvals. So they will say, unless we reach this percentage, the particular action cannot be taken. And the actions are typically actions which are significant actions. So, for example, settling a lawsuit, appointing a CEO, firing a CEO, changing the accounting rules that the company uses. So significant decisions. And what was interesting about this was that the threshold is 66% of the board. And that's interesting for a couple of reasons. So whenever I look at the supermajority, I look at two parameters. One is who has to make the decision? Is it the board or the shareholders? And after I've decided that, the question is, what percentage is required? So let's back up to whether it's the shareholder or the board. Why would you want the board to be subject to the approval? If you're the company, or maybe a smaller shareholder, or the maybe not the financial shareholder, the more decisions you can have coming to the board, potentially the better, because it's more efficient and because then the directors are subject to their fiduciary duties. If you are a financial investor who may want to take decisions for its own self-interest, not because they're bad guys, but because they're in the money-making business, they may want to legitimately take certain interests and take certain decisions in their own interest, and that would potentially compromise their position as a fiduciary. So I always, if I'm representing the investor, prefer that the rights such as this, the supermajority approval for a special decision, be allocated to the shareholders. If I'm representing the company, then for the smooth running of the company and to keep everything, keep people, if you like, a little bit more honest, I like it to come to the board. So that's just a nuance. The second question is then, what should the percentage be? Now, this company, and I don't know anything about the company, and I'm always, watch your shows, and I'm always kind of careful not to second guess the drafter, because I'm sure they have very good reasons for everything. They're smart people, and this is, for the most part, a very well drafted agreement.
I like your optimism about the drafting attorneys in every one of these cases, but yes, go on.
Well, it's a little bit of a hedge in case anybody reads
well
the
done.
point, right?
Well done.
So in this company, there are two directors. So if you say you need 66% of the directors, that means you need 100% of the directors. Right. You can't split somebody into two. Right. So, and this goes back to law school, right? The reason we go to law school is because we're better at English than at math. And right. So, what we have to bear in mind, and this becomes more complex in a company which has more shareholders and more directors. But I do think you have to be careful when you express the percentage as a percentage of the board, purely because of that arithmetical reason, right? The board's only going to have a handful of people at the most. And if you express that in terms of percentage, you're skewing the majority approval that's needed. So that was what stood out in this particular clause.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team team. If you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Yeah, and speaking of voting, jumping down to 203, it talks about deadlock, and specifically if you have two successive meetings and the directors can't reach the decision by that vote threshold, what do we do? 2.3 goes on for about a page. What are you thinking about this section?
I actually thought this was a fascinating section, and one that you really don't see very much in stockholders' agreements. You see it, if you see it, you'll typically see it in a joint venture scenario where you have two fairly evenly matched sides, or in a strategic investor where you maybe have a large corporate invest into a smaller company. You don't typically see it where financial investors such as venture funds or private equity funds will invest in a company. What's interesting about this is they call out three specific types of issues, which are, I think, one is a material change in the business of the company. Another one is initiating a public offering. And the final one is liquidating the company. So if the company was to take any of these three actions and the board are unable to, as you correctly said, reach an agreement after a couple of goes at it, then they go through this procedure. And what the procedure does is it says, if you're the largest stockholder, then you can buy me, the smaller stockholder, out. You can buy me out at a price which is equal to the fair market value. And conversely, if you're the smaller stockholder, what they call here the minority stockholder, you can force the majority stockholder to buy you, the smaller stockholder, out. So there's a call option and there's a put option. What I think is interesting in this particular clause and quite challenging is if you actually run through, there's various sections here, and each step of the way ends up really being a procedure involving 20 business days, 15 business days. And what they really set up is this procedure where from starting at that initial board meeting where there is no agreement, one party has to notify the other that there's no agreement and they wish to exercise the procedure. Then the next step is the other party responds, and then the other party responds to that response. And then they have to go and get a third-party appraiser to create an appraisal within 30 days. So if you think, and I'm deliberately paraphrasing here, but if you think that somebody wanted to suggest that bring an action that an initial public offering should take place or be approved on May the 18th, it could be well into September if you follow this through before you get to the state where you actually exercise the right to buy the other party out. So that's one observation, is that I think it's an interesting provision, but I think that the procedure is so long that I question whether it's really practical. Right. Now, that may be a reason why the drafter drafted it that way, because he's effectively, through this behavior, is forcing the parties to act rationally and to come to some kind of agreement. So it may be deliberate, but if it isn't, then it just, 3-4 months is a very long time when you're dealing with capital markets or decisions like this. There was one
undermine the transaction you're actually trying to make happen. It might actually undermine that, but to your point, if there's nudging going on, yeah.
Yeah, no, absolutely. If you're a third-party buyer or you're an underwriter in an IPO, you're not going to want to sit around to wait for all of this to happen, and it ends up giving one party a lot of power over the other party. But as we spoke about before, because this company is effectively a two-person board, it may be necessary, because if you can't unresolve that deadlock, then you're not going to go anywhere. So it's an interesting provision. Section E of this provision, I think it's section 203E, states that each stockholder shall take all actions as may be reasonably necessary to consummate the sale contemplated by this section 203, including entering into agreements and delivering certificates and instruments and consents as may be deemed necessary or appropriate. So the potential issue you have with that provision is it's what I would call an agreement to agree. So you go through the whole procedure and you imagine that the majority stockholder presents an agreement for the minority stockholder to sign. And then the minority stockholder has to sign that agreement. Well, it's a little bit too vague in terms of what that agreement says. Well, what if that agreement says, I'm going to give you all my share, I'm going to give you all my shares, but then I'm going to give you a 50% bonus, or you're going to give me a 50% bonus if you sell them on down the road, or you refuse to give any representations or warranties on your shares. Or it could be a million different things that might be in that agreement. So usually what you might see in a deadlock provision is much more specificity around what the selling stockholder will have to put in that agreement. It will often typically just be representations about the title that shareholder has, that seller has to their own shares, because that's something they should always be able to represent to. So that was an interesting something that just kind of came up that would make this procedure a little more difficult to accomplish if you went through the whole several 20, 30, 15-day procedures.
Awesome. Moving down to 303, it talks about the drag-along rights. Educate me about this section and what you do and don't like about whether it effectively does what this drag-along rights section is meant to do.
So drag-along provisions are something that crept into practice, certainly since, I would say, the private equity and venture capital from the 80s onwards became popular ways of raising capital. And they are built to cater for a situation where a minority stockholder may not want to sell their shares, but there may be an offer from a third party to buy all of the shares of the company. So let's say a big behemoth comes, sees the startup and says, okay, I would like to buy this company. And the venture capital guy says, that's great. I hold 60% of the company. And the big behemoth says, well, I don't just want to buy 60% because I don't want to be dealing with your minority stockholders. I'd like to buy everything. So there we have the drag along, which allows the majority stockholders to force the minority to sell their shares. So it's a pretty draconian right. Imagine somebody, you're living in a condo and somebody asks just because your neighbor wants to sell the condo, he can force you to sell the condo as well. So it's an aggressive right, but a necessary right for these financial investors whose goal is to liquidate their investment at some point. So what was troubling me about this clause, or rather what drew my attention, was first of all the threshold. So we spoke about this before about when we were talking about supermajority, is how large does the majority have to be in order to force the minority stockholder to sell? In this case, it's 51%, which that has a certain fairness ring to it, but it's pretty aggressive to cause 49% of effectively almost half of the company to sell their shares. So again, I don't know this company, and there may be some good reasons for it, but that is quite aggressive, and typically you would see a higher threshold, particularly if there were more financial investors in a company. The other provision that you often see in these types of agreements, and you don't see here, and as an aside, one of the things that I always look for in an agreement is not necessarily what's in the agreement, it's what's not in the agreement. So what's not in the agreement is a quantum, which requires the offer price to be at a certain level in order to cause the minority stockholder to sell out. So you often see, particularly if you have a financial investor, will specify a certain minimum valuation. So if the company doesn't receive an offer for at least $40 million, then this shareholder won't be required to sell their shares. So that's not here. It doesn't mean it's not wrong for being here, but that's typically something, if I was representing a financial investor, I would always want to see that here. Conversely, in a private equity scenario, they may say, I don't want those requirements, because if things are going really badly, I need to be able to sell this cheaply and get out of my investment. So there are all different constituent reasons why different parties may want different things, but that's just one of the things to look for.
Got it. And jumping down to 401, talking about the preemptive right, it talks about each stockholder given it the right to purchase its pro rata portion of any new common stock that the company may from time to time propose to issue or sell to any party. What do you think about this section? Do you like the language in the preemptive right section?
So this is a fairly typical provision, but there are a couple of elements that jumped out. One was in section 401B1. I don't know if you can scroll down to that. Mm-hmm. But to take a step back for a second, when you are offering preemptive rights to a shareholder, as you correctly said, it's the right to participate in an investment, in the subsequent investment in the company, in order to maintain your pro rata share. The way that you define pro rata intuitively is the shares I hold divided by all of the shares that are outstanding in the company. They use a particular term of art, which people in the business will be very familiar with, when they refer to the number of new securities proposed to be issued and the percentage of the company's outstanding common stock on a fully diluted basis. So what fully diluted basis means is, in my denominator, I count not only all of the shares that have been already given out to shareholders, but all of the shares that may be given out to shareholders. When I say may be given out, it would be options or warrants. So, for example, employee stock options is effectively a right to purchase a share at a future time. A warrant, which is really the same thing as an option in essence, but usually given to an investor, is the right to purchase a share of the company at a future time. So you may only have given out 100 shares, but there may be 10 employee stock options. So in order to really understand what your pro rata portion of the company is, then you would use 110 as opposed to just 100. So you're holding 10 over 110, not 10 over 100. So that math can significantly change things. And why? And sometimes you see these words fully diluted basis included, and sometimes you don't see them included. The reason why sometimes you may not want to have them in there, or at least be very careful about them, is where you have what are called out of the money options or out of the money warrants. So if in my theoretical startup, I raised money at $5 million and I issued warrants at that time to the investor to purchase shares at $100 million valuation. But now things have not gone so well. The next time I'm raising money at a $3 million pre-money valuation, which means that my value has gone down, and that those warrants at $100 million are really worth very little, because nobody is going to pay at a valuation of $100 million for buying shares in this company. Yet that goes into this calculation of full dilution and artificially inflates the number of shares there are in the company, and may mean that I have a smaller pro rata share of the whole. So you have to be very careful about the arithmetic when you're dealing with this particular formulation. So that's as far as the how much, what is the portion. The other part, which I think is just a bit interesting, is in section 401D. And this refers, maybe I'll read it. No later than 5 business days following the expiration of the exercise period, the company shall notify each preemptive stockholder in writing of the new securities that each preemptive stockholder has agreed to purchase. And that excuse me, they refer to it, their defined term they give it is an over-allotment notice. But what it's referring to is an over-allotment option. So there are going to be several investors in a company. Some of those investors may choose not to exercise their preemptive rights. And what an over-allotment option allows you to do is to buy the pro rata portions of other investors. So if I hold 20% and you hold 20%, we can each buy 20% each of the new round, but you may not elect to exercise your 20%. This allows me to buy your 20%. And in essence, it's not, if you're an investor, it's a nice right to have, particularly if you have deep pockets, because it gives you a way of hedging so that you can continually increase your percentage in the company, even over your pro rata portion. Sometimes if you're the company counsel, you may take a step back and try not to encourage it, because it could lead to one particular investor dominating the company if they have a lot more and deeper pockets than the other investors. So it's really a contextual thing, but it's something to look out for.
Gotcha. All right. Well, moving to the last section we're going to talk about is down to 9.11, amendment and modification waiver. This agreement may only be amended, modified, or supplemented by an agreement in writing signed by each party hereto, etc. Seems to be overlapping with some of the interesting questions that you introduced about, how many parties are actually involved in this kind of document. Talk to me about 9.11 and what you like and don't like.
So as an aside, one of the things I like to do, and I don't know if this reflects on me as an utter geek, is I really enjoy the miscellaneous sections of agreements, because that's where, when you're a young lawyer, you never really read it. You say, oh, it's all right. Boilerplate, I don't need to read this. But that's where really big mistakes and important issues can come up. And again, I'm not saying this is a mistake, but here, this agreement, and a stockholder agreement could have 20, 30 parties in it. It could have 3 or 4 parties in it. It could have 2 parties in it. If you require each party to sign any amendment of this agreement, you're in a way giving that party its own little veto right over future financings, because any party that is going to come in after this particular stockholders agreement is likely going to want to change the stockholder agreement. They're going to want their own preemptive rights. They're going to want to be part of the stockholder agreement, their own rights of first refusal, and their own board rights. And if you don't have the ability to easily change this agreement, then you are going to have to create all kinds of weird side agreements, or worse still, you may not be able to reach an agreement at all. So if you just imagine, if we kind of go back to the numbers, and you have your venture investor who may have 25% of the company, a couple of founders who have 40% of the company, some other smaller seed or angel investors, and then you may have one little family investor. You got your brother to invest in the company, you put in $5,000, and suddenly, because this agreement says each party here too needs to agree to an amendment of this agreement, your brother can hold up any further change to this agreement. And what you would really want to see, again, depending on who you're representing, is a higher threshold. So you would have maybe all investors of a particular class, or a particular majority, or a particular constituency of common shareholders or founders, and a particular constituency of investors, so that you can change it. You don't necessarily need everybody's consent.
Yeah, what's interesting to me, and as we wrap this up, I'm trying to pull out general principles. You see with a lot of these agreements, when people go out and they get these sort of stock agreements that they find wherever they find them, sometimes they're over-engineered for the context a little bit. It seems like, I don't know if I'm pulling out general principles, there seem to be some big company things happening with this small company engagement. What kind of general principles, if I'm a drafter, can you pull from this kind of document lessons that we might be able to apply to another context?
So I think the main thing is always really deeply try and understand who you're representing. It sounds obvious, right? But if you're representing a financial investor then you have to understand what their goals are. If their goals are really to be able to get out of their investment at some point, then you have to be focusing on the provisions which are going to give them the ability to do that. And you have to, as much as lawyers hate numbers, you have to really do the math, think through the numbers, think through how future dilution may affect percentages. That's if you're representing the investors. If you're representing the company and your company counsel, you want future fundraisings to be as easy as possible. You want the company to make decisions with minimal encumbrances. So you want to be de-emphasizing anything which requires a large constituency of votes. You want the voting thresholds to be lower. You want people to the procedures to be shorter. So it's really so context driven. Almost, I would say, as if you're creating a constituency of, a government or a constituency of politicians, which where I come from is where we've not had a government for a couple of years. Creating coalitions is a very challenging exercise, but that's what you're doing in a stockholders agreement. You're creating a coalition, and you have to come up with the most sensible governance arrangement that works for the largest number of constituents.
Yeah, and it's common with big deals like this. I think the cliche is that the contract becomes the client, right? That we get so focused on getting this document done that we start to let the document lead our decisions as opposed to the other way around. Well, I appreciate your context on that and your experience. It's very helpful in understanding these kind of documents. If people want to follow up with you to learn more about what you do and how to manage documents and deals like this, what's the best way to reach out to you, James?
So the best way is you could just Google me, James Raanan, or my firm, Parnes Raanan, and you will find me. So my email address is james@ParnesRaanan.com.
Awesome.
But there aren't many James Raanans in the world, so you'll find me.
Awesome. And I appreciate that. We'll make sure to include that in the show notes. If you guys go to lawinsider.com/resources, you'll find it there. Also, if you want to be on the show to tear down a document and be mean to the occasional, all the cool kids are doing it, just email us at community@lawinsider.com. We'll make sure to give you a place to have that conversation. James, thanks again for being with us, and we will see you guys on the next episode of the Contract Teardown Show. Thank you.
Thank you.